Hello again and welcome Disability Law Show. Good to have you along for another episode of it. John Scholes here along with my man James Fireman. We'll be wrestling the Disability Law Bull today, handling all the heavy lifting. Lots of stuff to get through today. Anytime you want to send an email, it might appear on the show, help@disabilityrights.ca. The website simply disabilityrights.ca. We'll give you links to our radio shows across the country pretty much, and the phone number is going to come up on the screen the whole show, but I'll give it to you right off the top, 1-855-821-5900. James, tons of stuff to get through, but you got a story to tell me as we get into it for this half hour. How are you, pal?
I can't complain, John.
Beautiful.
So one of the things that comes up on our shows quite often is that people are concerned, what happens if you start a claim? Can you go back to work? And what we always tell people is if and when you are medically cleared to return to work, that is exactly what you should do. Even if we have an ongoing legal claim, you should still go back to work if you're able to, because you're going to earn much more money by working than you will by trying to recover whatever you can from your insurer by bringing a legal claim. So that's advice that we give out quite regularly. But one question that has popped up that's in a similar vein but a little bit different is what happens after you've settled a claim? Are you able to go back to work? So here is what typically happens. We bring a legal claim and we resolve it at mediation, in most cases 8 to 10 months after the client has retained us to represent them. Usually it's at a mediation, and most of the time when we resolve a case, we're going to resolve it on what we call a full and final basis. It's a lump sum. So the insurance company is paying whatever they owe up until the date of the mediation, and then they're paying for several years into the future. How far into the future is going to be a case-by-case thing. It'll depend on the strength of the medical arguments. It'll depend on what we find in the insurance file and what kind of exposure the insurance company has. But we're going to settle on some amount of time into the future where the insurer is going to pay benefits in advance as a lump sum. So let's say, for example, they pay 2 years into the future. And so I've had a few clients come to me and say, well, what happens if after we settle the claim and during those 2 years I get better? What if I'm able to go back to work during that time?
Right.
Can I do that? And the answer is yes, you can. As long as there isn't an unusual provision in the settlement documents you sign at the end, which would rarely be there, as long as that's not included, you can go back to work whenever you're medically cleared to do so. And if you're wondering, well, isn't that unfair to the insurance company? First of all, I'm not going to shed any tears if something's unfair to the insurance company. But it is not unfair to the insurance company, and here's why. When you reach a settlement, you are trying to look into the future, but nobody has a crystal ball. And I can assure you that the insurance company is making every argument that they can that you're going to be able to return to the work as soon into the future as possible.
Right.
So if they have accepted 2 years in this example that you're not going to be able to work, that is truly what the best information available to both sides is going to suggest. In fact, it probably suggests further on, and perhaps you've just been fortunate that you've recovered earlier. And so, yes, if you were able to return to work within those 2 years, you would have the benefit of that lump sum settlement that the insurance company gave you and the benefit of the income that you're earning once you return, which seems like a windfall. But the reason it's not unfair is you think of the reverse situation. Let's again assume that you've settled for 2 years into the future. And let's assume after 2 years, you are still not better. You are still not able to return to work.
Right.
And at that point, what do? Well, I can promise you one thing. If you're not able to return to work after 2 years, your insurance company isn't going to say, hey, we shortchanged you. Here's some extra money for you for the extra amount of time that we didn't foresee that you were going to be disabled. The reality is, when you reach a settlement at mediation, both sides are assessing their risk and doing it as fairly as they can. It's likely going to wind up slightly unfavorable to one side as opposed to the other when everything shakes out. That's just the way it goes. But each side is accepting a certain amount of risk. So it's absolutely fine to return to work before that period that you've been paid for has been completed, because if you're not able to return within that time period, they're not topping you up either.
They would never try to claw it back?
This was a situation I was referring to.
Yeah.
It's unusual. There are very specific situations where an insurance company will insist that that language is included in the release documents that we always have to go through when we resolve a claim. But If the insurance company is insisting on that clawback, as you called it, that's what's generally referred to. If they're insisting on that being there, they're going to have to pay for that. Because, as I mentioned before, they are not going to pay you anything additional if you're not able to go back to work at the point where you've been paid all the way through. So if they're asking for that, which is very rare, I'm going to insist that they're going to pay a premium for that, and usually it's going to be significant enough that they drop it.
Does it change the situation at all if you've got this lump sum, you're off for some time, you go back to work and then you re-injure yourself, or so the same problem crops up again and you got to go off work again, you might be on more disability?
It can. So usually when you resolve a claim on a full and final basis, unless it's an unusual circumstance, part of that release is going to include a release of all future claims. Not always, each one is different, but oftentimes when you resolve your claim, you're giving up your right to bring a long-term disability claim with that insurer in the future. So if you were to go back to work in the future and re-injure yourself, you would not have access to that long-term disability policy. But that's not really a problem when you think about it, because if you were to go back to work, even if you can't have long-term disability insurance with that particular insurer, there's nothing to prevent you from buying a private policy from another insurance company, and if you then became disabled, you would be insured as long as you met their eligibility criteria.
3 things you must know as an LTD claimant if you're attempting to return back to work. We'll do that a little later on the show. Kind of relates to what James was talking about, so stick around for that. There's also a website you can go to as well called pocketemploymentlawyer.ca. I know it says employment in there. That's the other show we do. But there's a pretty robust section there on disability law. I know James referred to it before. You can use that anytime you like. It covers everything to do with employment law, of course, and disability law is there as well, because there's lots of overlap between the two. So at your leisure, you can go to pocketemploymentlawyer.ca. And have a look at that. Want to get to the first email, as mentioned, James, again, help@disabilityrights.ca is the way you do that. It's going to be Diane. Diane's the first email today. Says, I have osteoarthritis in my spine and my back pain was getting so bad. My doctor told me to take time away from my job as a janitor. I was denied LTD because my pain was not, quote unquote, bad enough, according to the insurance company. In light of this, my doctor says he can clear me to return to work, but only with extreme limitations. However, my boss is refusing to accommodate. Have I run out of options?
So you certainly haven't run out of options. Now, whenever I see something about a duty to accommodate and requiring extreme accommodations, I'm always thinking about my partner Lior and how that would be impacted in an employment law case. And certainly if the employer was not willing to accommodate, it becomes something that we're looking at from an employment law perspective. But when I think about what's required here, what Diane is suggesting, extreme accommodations, if you require that in order to return to work, that really suggests to me that you have a disability. If you are not able to return to work without extreme accommodations, are you really able to work at all? Based on a typical policy, in most cases, I would say no. Now, again, you'd have to take a look at the very specific circumstances. So what exactly are these extreme accommodations that Diane requires, and what exactly is required of her in her role as a janitor? I mean, you can take a guess at what it might be, and it seems to me that unless you're really able to do the fundamental task of your job, you're disabled under the policy. So if there's an employment case, certainly we would go through our employment law team, but failing that, if you require the extreme accommodations, that suggests to me you're not able to work. So we would start a legal claim, and we would pursue the benefits that you're denied through a legal claim and go from there.
She said extreme limitations. Now, there's that part in a disability policy where you go from the 2-year mark to you can't do your own job. There's another step after that, which you might have to go through as well, right? If it goes that long?
Sure. So after the 2-year mark, the test for whether or not you're entitled to benefits changes. And it's no longer whether or not you can return to your own occupation. It's whether or not you can do any occupation you're qualified for by training, education, or experience. So whatever accommodations she may require within the first 2 years may have no relevance at all to what's going to be required for some other occupation. In other words, if she needs accommodation to do what is a physically demanding job, like being a janitor, that may not exist if she is capable of doing a more sedentary job, a job where she can sit at a desk and use a computer. Again, I would have to look at the specific information in the medical file and see whether or not that's true in this case, but you're quite right. The accommodations required in the first 2 years may be entirely irrelevant after the 2 years, and so after that point in time, it may well be that Diane is out of luck. But for the first 2 years, it sounds to me like there's a legitimate claim there, and if they've cut her off early, then she'd be entitled to recover.
All right, short break. As mentioned, coming up here, 3 things LTD claimants must know and do before attempting a return to work. That is on the way. In the meantime, 1-855-821-5900, help@disabilityrights.ca is the way you can email us. We'll get back to it. Disability Law Show. Stick around. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Disability Law Show. John Scholes, James Fireman, 1-855-821-5900. Anytime, write that number down. Keep it, if only for yourself or a friend or a family member who's too bashful to call. You can do it for them. help@disabilityrights.ca is the email address we use. James, as mentioned, want to get into this. 3 things you must do as an LTD claimant. You must know and do before attempting a return to work. You have to confirm that there is what they call a recurrence clause in your LTD policy. Break that down for me, pal.
So a recurrence clause is in any standard long-term disability policy, and what it says is that if you are receiving long-term disability benefits and you are approved to return to work, you get medical clearance, and you attempt to return to work and you're not successful, if it's within a specified time period, you're going to be entitled to go back and receive benefits without having to go through an elimination period. So just stepping back for a second, when you initially apply for your benefits, for your long-term disability benefits, there's typically a 3 to 6 month waiting period where you have to be continuously disabled, but you're not receiving any long-term disability benefits. After that waiting period or elimination period is completed, you would start receiving your LTD benefits from that point forward. The recurrence clause says that if you are disabled and then are able to return to work, and then you are disabled again within a specified time period, you don't have to go through that 3 to 6 month elimination period, so you can go right back on to claim. And it's really an important provision, and it serves the interests of both sides. The reason I say that is because from a claimant's point of view, it allows you to try and go back to work without being worried that if you do so and you're not successful, that means your benefits are terminated. So you don't necessarily have to be 100% sure that you're going to be successful to attempt to return to work, because this recurrence clause, at least in theory, is going to protect you from that. From the insurance perspective, it also makes a lot of sense too, because they certainly want to encourage anybody who's receiving LTD benefits to return to work. If you're able to successfully do that, that means they're off the hook, and that's how they make money. So I assure you, they have a huge interest in encouraging everyone to try and return to work. Now, the little caveat I threw in there, the reason why I said that's how it's supposed to work in theory, when I was talking about the ability to go back on to claim if you're not successful in returning to work, is because what we see in practice is a lot of times people will try to go back to work, they're unsuccessful, and the insurer will still not reinstate their benefits at that point, and they'll conjure up some sort of justification based on the fact that you were able to try going back and suggest that perhaps you just didn't try hard enough. We do see that happen very frequently. And so what's really important is if you're looking at this, you're being really careful to make sure that your doctors have approved you and that you feel confident. If you don't feel confident that you're going to be successful in returning to work, it's pretty unlikely that you will be. So you should be waiting until you get medical approval and you have significant confidence that when you try to go back to work, you're going to succeed.
Well, and that's the second point. Before you just decide to say, hey, I feel good, I'm walking out the door, I'm going to go back to work. No, you need to contact, if not go see your medical team and make sure you have approval. If you don't, how will that affect you with your insurance company?
Well, if you don't go get medical approval before, your insurance company is, they can use that against you if you're not successful. So if you just go back to work saying, I'm going to try doing this and no one's cleared you, it wouldn't shock me at all for the insurance company to say, well, you went back to work before you were ready to, and as a result of that, because you didn't have medical clearance, you're going to be disabled for a longer period of time because going back to work, in fact, harmed you. And because of that, we're not responsible for what happens from here on out. It wouldn't surprise me at all to see an insurer take that position if you went back against medical advice or at least without approval.
So they can tell you to go back to work prematurely when you're not ready and try to force you back to work, but then if you take it on your own initiative to go back to work, they can tell you shouldn't have gone back. Nice.
Right. Well, listen, you're putting a couple things together that I don't know that I necessarily agree with. If they're telling you to go back to work, they don't have that argument.
Right.
But if you're going back to work on your own, if you're the one who's suggesting it and you haven't gotten medical approval yet, then the insurer, I think, would use that argument I was talking about before, that if it wasn't successful, it's because you went back too early. If they're telling you that you should go back to work, they can't really argue that. It wouldn't be an available argument for them.
Again, reaching out anytime, 1-855-821-5900 to get a hold of James or a member of the crew at the firm is no problem. We are talking the 3 things LTD claimants must know and do before attempting that return to work. Number 3 is this: confirm with your adjuster in writing that if your attempt to return to work fails, that you will be placed back on LTD.
Yeah, I mean, that's always a good idea. Now, you're not likely going to get the response that you might hope for. In other words, you're saying to the adjuster, hey, I want to make sure that I can go back on. What I expect the adjuster is going to respond with in virtually every case is they're essentially just going to cite the provision in the policy where you find the recurrence clause. They'll basically repeat that verbatim, email that to you and say, well, there's recurrence clauses in here, so if you're not successful, then this is what would apply. They're not going to say, yes, we're going to reinstate you, because that's putting them in a position where they're not allowed to analyze what's gone on. And they're entitled to do that. It doesn't mean because you've returned to work and you weren't successful that you're automatically approved. It just means that you have the right to be approved without the elimination period. But they're entitled to look at the reasons why. If you weren't successful because you've done something to ensure that you weren't going to succeed, your insurer would be justified in not reinstating you in that circumstance. So they are going to have a look at it. But there's a good reason for asking your insurance company, your adjuster, to do that, to provide you with that assurance that if you aren't successful, they're going to put you back on. And it's simply this: you want to create a situation where you are sending the message that even though you're attempting to go to work, it's not because you're 100% sure that you're going to succeed and that you're absolutely ready and you no longer need benefits. It's because you're trying. It's because you want to be able to go back, you want to succeed, but you're leaving room, that area of doubt, where you don't know what's going to happen in the future. And rightly, you don't. Until you've tried it, you don't know whether you're going to succeed. So you want to make sure that there is at least that little bit of equivocation on the record, in writing, so that the insurance company can't turn around and say, well, you said that you were perfectly fine and we're ready to go back to work. You'll have that. You want to make sure that that's in writing so that you can refer to it later in the event that you try to go back to work and you're not successful. Now, again, I'm going to refer back to what I had said earlier. Yep. You still don't want to make the attempt unless you're reasonably confident that you're going to be able to go back to work. But you don't need to share the degree of confidence that you have in the likelihood of success with the claims handler. Keep that to yourself. Just say, I'd like to try to go back to work, but I want to make sure that if I try and I'm not successful, that I'm going to be able to go back on to claim. Again, what the insurer replies with doesn't necessarily matter, as long as you've put that out there that you want to make sure that you have this as an available outlet for you if things don't go well.
Well, you'd think as well that if you're doing that and taking that step, that the adjuster and the insurance company on the whole, since they're a money-making organization, they would appreciate you trying to mitigate and get back to work and get off claim, no?
Exactly. They want to make it easy for you to try and go back. I just don't think that they're going to give you any kind of assurance that if you're not successful, they're going to start paying you benefits again. The most they'll do is confirm that there's a recurrence clause in the policy, which means that you have the right to ask for that, and if they agree that you remain disabled and that through no fault of your own you weren't successful, in that circumstance they would continue paying benefits. But again, frequently we see when people attempt to go back to work and they're not successful, the insurance company, despite the recurrence clause, will use that against them, which again is why I say don't go back to work until you have the medical clearance to do so and you are personally confident that there's a high degree of likelihood that you're going to succeed when you do.
Next thing we are going to tackle is there a deadline to appeal your LTD denial? That is on the way. First, though, short break. Reaching out, help at disabilityrights.ca. That's the email address. Simply disabilityrights.ca is the website, and the phone number anytime, of course, 1-855-821-5900. Stick around. We're coming right back. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, Disability Law Show still got a few minutes to go. James, want to get to something from a website we call mydisabilityquestions.com. It's the first time we're going to use it today. You can go there anytime to ask your disability law questions. The nifty thing about it is it's got a searchable database, which means that a question similar to yours may have been asked in the past. You can search it, see if it is. If not, leave it there. James or a member of his team will answer that question. Again, mydisabilityquestions.com, absolutely free and anonymous for that matter. Kira is the one we're going to go to, James, so I'll let you ruminate on this for a sec. What happens if I miss the insurance company's deadline to appeal the denial of my long-term disability claim?
Well, Kira, I'm going to let you in on a dirty little secret here. The insurance company wants you to appeal. The appeal process is something that they have made up. It's a completely arbitrary process. You won't find it outlined in your policy. You're not going to find it in any statute. It's something that they have made up to provide you with false hope that if you ask politely and you give them just a little bit more, maybe they'll change their minds. It's not going to happen. They want you to appeal because they completely control that process. They've made it up. The person who's going to decide your appeal is usually going to be the same person that's denied your claim in the first place. And if it's not, it's likely their direct supervisor. It isn't going to someone who's looking at it with fresh eyes, someone who is unbiased, who is going to make a fair decision. Mm-hmm. It's going right back to where the decision was made, and your insurance company has an interest in cutting you off. They're a corporation. They're in business to make money for their shareholders. The only way that they do that is by denying claims or cutting off claims that have been approved. That's the only way that they make more money. And once they found that justification, you're not likely going to change their mind unless you force them to. And the only way to do that is by taking it out of their hands. If you appeal, you are leaving it in their hands. They have complete control. If you bring a legal claim, now it's in the justice system. Now they don't control the process, and all of a sudden, they become very reasonable. So if you're concerned about what happens when you miss that appeal deadline, don't. I mean, if you really, really want to appeal for whatever reason, they're going to let you even if you miss the deadline. It's like when you watch those infomercials and they say, oh, if you call in the next 30 minutes, we're going to give you this nice set of steak knives. I guarantee you if you call in an hour or in 5 hours or the next day, you're going to get those steak knives. Likewise, if you miss that appeal deadline, your insurance company is almost certainly going to allow you to appeal. But why would you? It's a waste of your time. No. And even if your insurance company decided in that scenario that they weren't going to allow you to appeal, so what? As long as you're within the 2-year limitation, 2 years from the date that they cut off your benefits, you can still bring a legal claim, which is what you should do in the first place anyway. So, long story short, it does not matter.
Yeah, people think it's court of appeal, not just appeal. It's the same company that's doing the appeal, right? So why waste your time?
Don't get me started on appeals.
I know, seriously. But we will get to one more email here in our remaining time. Georgia, again, help at disabilityrights.ca is the email address. She says, guys, I'm getting LTD benefits for a torn left shoulder. I'm 59 and have worked outside most of my life. My doctor is telling me I need surgery for my shoulder and possibly my elbow, but COVID is making it nearly impossible for me to see the surgeon and get scheduled for surgery. Will my benefits be cut off while I await treatment?
It's a really good question and obviously very topical right now because many people are having a lot of difficulty getting any type of physical therapy. Any type of treatment that requires you to be in person with your treatment provider is just exponentially more difficult. And there are many treatment providers that are simply not able to operate right now. You have a duty in your policy to make all reasonable attempts to get treatment, the necessary and reasonable treatment for whatever your disability is. And if you're in a situation where we're in the middle of a pandemic and you are not able, you're just absolutely unable to get treatment because nobody is allowed to provide it to you, there would be no justification for your insurance company using that as a basis to cut off your benefits. Does that mean that they won't? Well, I would hope not. Mm-hmm. I would really, really hope that they would not do so. It seems to me like if they did that, they would be exposed to significant damages for punitive damages if they did that. It would really be something that obviously is breaching the duty of good faith. So I wouldn't anticipate them doing it, but then again, stranger things have happened. I've seen cases where it has. If they were to do that, by all means, give us a call because that is something we can absolutely help you with. And again, it's something that as soon as you bring a legal claim, and you take it out of their hands, all of a sudden they're going to become much more reasonable. Part of it's because they don't control the process anymore, and part of it's because when you are arguing with your insurance company on your own, you're dealing with the claims department, and they have an objective to cut off and deny as quickly as possible. But when you start the legal process, you bring a legal claim, you hire a lawyer, all of a sudden it moves from the claims department to the legal department, and it gets assigned to a new claims handler and to a new lawyer that are looking at it with fresh eyes and that understand the exposure that the insurance company has in that particular situation. They understand, first of all, that they don't have a right to cut off benefits if you are absolutely unable to get the treatment that you need. They will understand that. They're also going to understand that if their claims handler in the claims department has actually done that they're going to have to pay significant damages if it ever got to court in punitive damages, and they want to avoid that at all costs. One, because obviously it's going to cost them a lot of money, but two, it's going to be really, really embarrassing. It's a PR nightmare for them. And so they don't want this coming anywhere near a judge. So if they were to do that, we bring a legal claim, and I can assure you they're going to get reasonable very quickly.
You know, it's funny you say that. It'll go from that level to their lawyers, is what you said. Now, most people, the novice or the person who doesn't know would say, well, that's kind of scary. That's actually good because now you're dealing with someone who's on your level and understands to move this along quickly, right?
Yeah, as frustrating as it can be for many of our clients to be dealing with the claims handlers because they do things that don't seem to make a lot of sense. When it moves from the claims department to the legal department in the insurance company, that's rarely the case anymore. I have a lot of respect for my colleagues on the other side of the table when we're at mediation, and I've never gotten the sense that any of them didn't understand what they were doing, didn't know what the exposure was. We will frequently disagree on how to value that, right, but they are certainly more than competent. They understand what's happening, and they aren't the people who have made that bad decision in the first place. So they don't have any personal investment in maintaining what is really an indefensible position in most cases.
Again, mydisabilityquestions.com is where you can go anytime. It's a searchable database. Ask your questions there anytime you like. Mydisabilityquestions.com. It's anonymous. It's a wealth of information. Again, you might get your answer even before you leave your question there. 1-855-821-5900. Disabilityrights.ca to find our radio shows across the country. And the email address we always use, help@disabilityrights.ca. We'll catch you next time on the Disability Law Show. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.